My name is Volker Kruger. I have Alicia Cusack here with me from Velden-Duffey attorneys to talk about the recent court case dealing with the liability of the Department of Education for a teacher's conduct and the appointment of the teacher with a criminal record, etc. But yeah, Alicia, please firstly explain to the listeners the facts. What was this case about?
So the facts of this case are actually quite sad, I think, and a bit of a listener discretion or viewer discretion is advised because it is about the sexual assault of a minor. So what happened in this case in 2011, the plaintiff in this case is just referred to as AH8. She was 12 years old in 2011, and she was attending the Vlei-Plaas Primary School. So while at school, the first defendant, Mr. Swanepoel, asked her to come and assist him in his office. At that stage, he was a teacher and the acting principal of the school. When she got to his office, he actually ushered her into the staff bathroom, where he then proceeded to sexually assault or rape her. And afterwards, he then had her clean up with a rag that he had with him and just ushered her out of the bathroom. So immediately following this, she did actually institute criminal proceedings against him, but after a while they were dropped. So this isn't the criminal case, this is a civil case, and it takes place approximately, we're now in 2022, the judgment I believe was handed down late 2021, but let's, for argument's sake, call it about 10 years later. So she, in this case, is pursuing civil liability. She is trying to hold the teacher liable for the damages that she suffered. So he is the first defendant. But she's also trying to hold the Department of Education liable because she is saying the Department of Education had a duty to protect her as a student of the school and do a greater, I guess you could say, due diligence before allowing this man to be a teacher and to be registered as a teacher at the school.
If he were to be found criminally liable, then obviously he would go to jail for a number of years. So this is now civil liability, as you mentioned. So she is claiming damages in the form of funds, monetary funds that have to be paid to compensate her for the damages that she suffered as a result of the rape. And she claims that from him, obviously, as the perpetrator, but also from the department.
Yes, so it is important. Why that is an important distinction is firstly, we don't then necessarily refer to him as being guilty because he isn't found guilty of a crime here. He's either found liable or not liable. So this won't reflect on his criminal record. And secondly, the onus that she has that rests on her to prove that he assaulted her is slightly lower. So when we're dealing with criminal matters, she would have to prove, or rather the state, the prosecutor would have to prove beyond a reasonable doubt that he committed this assault. Here, she only has to prove it on a balance of probabilities. And when it came to her case, she was actually, quite lucky in the sense that she had two teachers who corroborated her story. So apparently what happened is this, Mr. Swanepoel had previously done things and conducted himself in a manner that another teacher, a Miss Keys, I believe her name was, started getting suspicious about the way he was treating this specific pupil. She had apparently found them to be in a disheveled state in a kitchen on a previous occasion, and so when she noticed that this student was missing because she was supposed to be attending to assisting the teachers with another matter, she went looking for her. She then actually knocked on the staff bathroom. Mr. Swanepoel answered and essentially said, "Oh no, occupied." And then she went and stood under a tree so that she could see who would be leaving the bathroom. And she then saw the little girl walking out of the room, the bathroom, followed by Mr. Swanepoel. So obviously she didn't see the actual assault, but a lot of what she witnessed matched up with what the little girl back then and now as an adult what she testified to. So with regards to Mr. Swanepoel, he was found to be delictually liable. They said that on a balance of probabilities, the court found he had committed a delict by physically, sexually assaulting her. So that part of it moved out of the way. But then where the case got quite interesting is when we get to the Department of Education. Because obviously...
Can I interrupt you there? You say that the standard is slightly lower, but I think in many cases, also in this case, there is a substantial difference between having to prove on a balance of probability as opposed to proving beyond reasonable doubt. Because in a criminal case, if there's any doubt whatsoever, then the court has to find that accused not guilty. Whilst in the civil case, as you mentioned now, it's a balance of probability. So you basically start on the same level, and then it's for the court to decide who the court believes more. So it's a scale that is level at the start of the case, and then if the version is more probable because there are witnesses who confirm, for example, that version as you now mentioned, then you sort of win the case. So I think it's obviously much easier to win a civil case as opposed to a criminal case. But be that as it may, the next legal question, I guess, is the liability of the department. What happened there?
Yes, so obviously when you've got someone like Mr. Swanepoel who actively did something wrongful, there's this perception that what he did is, on the face value of it, a wrongful thing that he did, and he should be held liable. So if we take the example of maybe a physical assault, if you slap someone, the jumping off point is that what you did was wrong. Then you have to raise a defense and say why it might have been justified. Obviously, in sexual assault cases, you're not going to have a justification, but we still start from the jumping off point that what you did is wrong. However, what we're dealing with the Department of Education is not that they actively did something wrong, is that they failed to do something. So in this case, they failed to prevent harm to the child. And what is
for example, another example would be a policeman who fails to act if someone is, for example, attacked in the street. Then there's no specific conduct that leads to liability. It's actually the failure to act which could lead to the liability.
Exactly. And the first thing that you have to consider when dealing with a failure or an omission is, was there a legal duty on this party to do something? So an example they always used for us at university was, you as a normal person are walking by a river and you notice someone drowning, but you yourself aren't a very good swimmer. There's no duty on you to jump into that river to save that person. You cannot then be held liable for not, risking your life to try and save them. But let's say the circumstance differs, such as a policeman who has taken an oath to, protect the public. He sees someone being assaulted in front of him and he just stands back and does nothing. Then you can be held liable. You had a duty on you to actively intervene and do something, and your failure to do so is wrong. So the question here was, what was the duty on the Department of Education? So they said the Department of Education has a duty to vet teachers. They must confirm that they are suitable people to be teachers. So in this case, what it came down to is a form that the defendant had filled in. So Mr. Swanepoel had completed a form in which they asked him, had he previously been convicted of any crime related to his work? And he answered no. He said, no, he hasn't. Although he had previously been convicted of sexually assaulting a 15-year-old. And his rationale was, well, that wasn't in the scope of my work, so I didn't feel the need to disclose it. So the court essentially said, well, firstly, to put it a bit bluntly, that's a stupid question. why are we limiting it to within the scope of their work when we are dealing with children? We are dealing with a portion of the population that is extremely vulnerable, and now you're concerned whether he did something wrong within the scope of his work.
Just repeat that question, please. You say?
So they asked him whether he had previously been convicted of an offense, but within the scope of his work, within the scope of employment. So, maybe some administrative offense, I guess. So they said, firstly, that was a problem. The second thing was that the Department of Education never actually fact-checked these forms. So if they would have gone and they would have, compared it with his SAP's criminal records, they would have found that he had previously been convicted of a sexual offense, but they didn't do any due diligence. And the reason for that was the Department of Education. So the school was pointing their fingers at the Department of Education. They went, we didn't do it because the Department of Education was supposed to do it. The Department of Education went, well, we didn't do it because the SACE, which is the South African Council of Educators, they were supposed to do it. And the South African Council of Educators went, well, actually, in 2011, it wasn't a requirement for us to do it. They only introduced the police clearance certificate requirement in 2018, which is, I think, for any parent or any reasonable person, quite a shocking thing to hear. So everyone was pointing fingers at everyone, and the court just said no. At the end of the day, it is the Department of Education who bears this responsibility. They are the people who allow persons like Mr. Swanepoel to be registered and employed as educators, and they should have done a due diligence. And this thing came down to two things, and it was actually testified by the representative of the Department of Education. One, it is reasonably foreseeable that persons such as the first defendant pose a high risk to children. Any reasonable person who is employing an educator should foresee that someone who has been previously convicted of sexual offenses, specifically with regards to minors, should not be employed as an educator. And they said, secondly, it was reasonably preventable. If the Department of Education had firstly had him fill out a proper form, and secondly, had double-checked what he said on this form, then he would not have been employed as an educator. And on those grounds, the court said the Department of Education had been liable, negligent, and should be held liable. So they are actually jointly and severally liable with Mr. Swanepoel for the woman's damages, which will now be determined at a later stage. So what they did here is they first dealt with the merits, with the liability, and now they will later deal with her damages that she suffered.
Jointly and severally, meaning that the full amount can be claimed from either of them.
Yes.
So if they claim it first from the department cannot say, no, you must get a portion of that amount from the Mr. Swanepoel. No? So that obviously also helps in terms of recovering that amount from the two defendants in such a case. Yeah, so the advice obviously for the department is there's a legal duty according to this court to vet the teachers carefully and specifically check their criminal record and make sure that your questions are worded properly. But it looks like the question as such, even if it had been worded properly, that wasn't good enough. The court said it's so important to protect the children. You have such an important duty to do so that you actually need to check the criminal record of every teacher that you appoint.
Yes. I do think it's important to note that there's a very high probability of this case going on appeal. So this was actually the Western Cape High Court. It happened in the Western Cape. The Department of Education, I'd be very surprised if they don't appeal this judgment, specifically because there have been a lot of previous cases where parents have tried to keep the Department of Education liable, such as where children might have been injured on, playing equipment and and things like that. And every time the department has escaped liability. So this does create a very big precedent that the department isn't untouchable, and that there is a big duty that rests on their shoulders. So for now, yes, the department, I think, the Department of Education, irrespective of this case, should be doing a better job. Themselves, the SAC, all the organizations that are involved here, they should be doing a better job. They should be, double checking criminal records and doing everything. So even if this gets overturned, I wouldn't think that they should just wash their hands and be like, oh, well, we've gotten off scot-free.
I hope that they are doing that in the meantime. In any event, I think you mentioned something about 2018. They started implementing that. No? So hopefully that won't happen again. Maybe I can just add, it's perhaps good advice for any employer to always get the criminal record of any applicant for a position verified. There have been some cases where employers have employed someone who was previously held guilty or found guilty for actually theft, and then that employee again stole from that employer who employed him without checking the criminal record. So that's certainly something that I think should happen with any employee being employed, and not just a teacher.
Yeah, definitely.
All right. Thank you, Alicia.
Thank you.